Before we begin, we wanted to let you know that this conversation covers sensitive topics, including sexual harassment and sexual assault. So welcome back to the F Word, and today we have Joe Nicholls, who's an employment lawyer from Stephens Scown, and your F word is freedom. And we're looking at this in a slightly interesting take around freedom from sexual harassment and some of the new laws that are coming in or changes to those laws. So before we get into that, can you tell us a little bit about you and your role?
Yeah, sure. Thanks for having me. Good to see you, Laura. I'm an employment lawyer at Stephens Scown. We are a full-service commercial law firm operating throughout the Greater Southwest. We're based in Cornwall, Devon, and Somerset, with expansion plans later this year. And we cover a full suite of commercial legal services, including employment law. So we have a specialist team of employment lawyers. Um, and we advise businesses and individuals on employment rights and duties and obligations. My part of the team, I'm a partner in the team, and I lead on the employment tribunal dispute work. So things get serious when it
Yeah.
comes to me. I'm generally, team and I are involved in the day-to-day representation of individuals and businesses in bringing and defending claims and the disputes and negotiations that go on before that.
And have you always been an employment lawyer? Or
I've practiced for about the last 15 years or so. I Before that, I was in an area that I knew I didn't want to be in. Was at a firm in London, and sort of circumstances meant that I could move into an employment practicing role. It's just a brilliant area of law for me. I think it's day to day. It's always very different. You've got lots of commercial and strategy elements to it. You've got that personal human touch to the law when advising individuals about things that make a real difference to them. And you've got contentious and non-contentious work. So there's a whole range of variety to employment law that makes it a really interesting area to practice in.
I'll take your word for it. It's
Yeah.
too wordy for me. I'm definitely more than numbers, but we've worked with your team on setting up things for us here, so kind of had a bit of exposure to that. And as we said before we started filming, I've not been told I need to speak to you yet, so hopefully that means things are
Yeah,
all okay.
it's going all right.
So your F word, freedom, we're going to have a little conversation about the context of that. So can you talk through at the moment how the law currently protects employees in that respect?
Yeah, sure. So to sort of inform sexual harassment law, just to look at the bigger picture slightly, you've got the Equality Act 2010, which is a piece of legislation which essentially protects people from discrimination and harassment and unlawful treatment in the context of protected characteristics. So there are a series of characteristics which are protected under the legislation: age, race, disability, sex, etc. Um, Within that, you've got various different types of discrimination and harassment. Harassment then is defined under that piece of legislation as unwanted conduct, which has the purpose or effect of violating someone's dignity or creating an intimidating, hostile, degrading, offensive, or humiliating environment for that person. So that's quite wordy in itself.
And sounds really extreme, but it's actually in real life things that fall under that aren't extreme necessarily.
Well, there's certainly a range of things that can
Yeah.
could be captured by that. You get different types of. I mean, firstly, it's some of it is subjective, so it's
Mhm.
how it affects someone. I mean, just to unpack it, you've got unwanted conduct. So some sort of treatment, something that can be something said or done to someone. That can be some sort of treatment. It could be potentially something like dismissal. Um, so it's not wanted in the first place. That's one of the key elements to it. Um, I guess the second point is that it has the purpose or effect um, of creating the environment needed for harassment. So it's either done deliberately to um, humiliate someone because of their age or disability, or it isn't, but it's had the effect of that on that person, and that's important because might not be intentional, but it could still be unlawful. And then it has to obviously be related to the protected characteristic as well. And then in the context of sexual harassment, there's a slightly different element to it, which is that it's unwanted conduct of a sexual nature. So it has to be, and that in itself can be defined in lots of different ways. But that could be messages, that could be inappropriate touching, that could be um, other types of conduct. I've advising people at the moment who've been stalked, who've been sexually assaulted. We have clients who've been raped. Some of the more extreme
Okay.
examples that you would think obviously fall
Yeah.
into that category, but there can be much more subtle sharing of messages, following on social media and commenting, which is quite common. WhatsApp groups amongst teams where you're sharing um, memes,
Yeah.
even something as subtle as that, which is happens all the time, but can create that environment for someone who's part of that group.
It's yeah, it's awful that there are people that experience those things, especially when you're talking about the extreme nature of some of what you see in their workplaces. And I think that helps to set the context of why these laws exist. Because again, we were talking before we filmed about how quite flippant comments can be made around, oh, it's all gone too far now. It's just the law is just, we can't do anything. But when you look at those extreme cases, it's there for a reason because this is what can and does happen if there aren't parameters, there aren't boundaries, and there aren't things to deal with. So I think it's, yeah, although it's a strong message, it's helpful to understand why these things exist. They're not there to be a pain for an employer, they're there to protect
Yeah,
everybody.
absolutely. I mean, it's um, some of those examples I just listed are extreme examples, and you don't see them all the time. Um, but they are part of the same category of
Yeah.
types of offences, which the Equality Act is there um, to outlaw.
So how is the law changing and why is it changing?
Okay, so we got bear with me here because we've got a few different areas to talk about. The first is a change that's already in place that
Mhm.
came into place last October. So from the 26th of October 2024, the Equality Act changed to insert a provision to provide employers with a proactive duty to take reasonable steps to prevent sexual harassment.
Okay.
So, specifically for sexual harassment, employers now have to take a proactive duty to prevent it from happening.
And what might that look like? What is, how have you seen that in practice, or what is, in layman's terms, what might that mean?
Well, it means lots of different things to lots of different businesses, actually, but some of the sort of fundamental practical steps, maybe we'll come on to, but certainly things like having the right policies in place, having the right culture in place,
Mhm.
having training for everyone in the workplace. Really, just to sort of give it a headline, it's making sure that everyone knows what the expectations are and what is and what isn't acceptable in that context.
Okay.
Um, so that change is already in place, and really the impact on employers is financial.
Mhm.
Um, you have there is now a 25% uplift on any compensation for any successful sexual harassment claim where a tribunal finds that they didn't comply with that proactive duty.
Okay.
So that happened. That's already in place, and that means we've spent the last year and slightly before going around with our commercial clients, delivering training, helping them understand what that means, getting in place risk assessments, generally assessing their workplace for those risks and what they need to do to um, proactively prevent it. There's then some future changes coming in. Most people will know about the Employment Rights Bill,
Mhm.
which is currently going through Parliament. It's subject to change, so anything we say right now could change before it comes into law, probably next year. But the pretty well understood provisions of that, at this point at least, are that there will be a new duty for employers to prevent um, sexual harassment and harassment actually from third parties.
Okay.
So again, it's expanding that liability for employers. It essentially says for any customers, suppliers, visitors, guests in your business, you as an employer are responsible for any sexual harassment um, that your employees suffer as a result of them. So, uh, and that change is controversial.
Mm.
Um, it used to be in place and up until 2013. It was then repealed at that point. The controversy is how can an employer who doesn't have any control over third parties um, control their behavior essentially, and that's very difficult to do. Um, if you think about, we've got clients who are hotels in the region, just the number of people that come in and out of their door every single day, it's just very, very difficult to know how they can really um, comply with that. So that's going to create difficulty. Um, and just the third one is that again, the Employment Rights Bill proposes to extend the time limits for bringing claims. So currently, it's 3 months less 1 day from the date of the act. In this case of harassment, um, that will extend to 6 months less 1 day. So it gives people more time, perhaps, to see what their employer is going to do about their complaint,
Mhm.
and decide, maybe take legal advice and decide whether to pursue a claim or not.
And I think that's important, just that last point there you said about time to see if what their employer is going to do is all of these things, there are still processes to go through. These aren't that those don't exist anymore and there's this new set. These are things that have expanded on what's already there. So if someone has a claim, there is still a process. No, it's not going to be a suddenly naught to end goal, is it? There'd be something that needs to happen if an employer has knowingly or unknowingly found themselves in a situation like this.
Yeah, absolutely. And I think it's important not to lose sight of the fact that lots of that in the Equality Act already there is a defence to a claim of harassment, where an employer takes all reasonable steps to prevent it. So you can defend it. You
Mhm.
can absolve yourself of liability potentially if one of your employees has acted in a way that you don't condone. Um, if you can show you've taken all reasonable steps to prevent that, then as an employer you wouldn't be liable for that. So it is an evolution. It's not simply a jump, a change of scene. It's probably just recognition that culturally, as a society, we aren't doing what we should do
Yeah.
enough, and um, certainly there's more to do to combat discrimination, harassment of all sorts.
Absolutely. And for businesses that are wanting to start thinking about these steps, as you say, it's not sort of in writing exactly what this is going to look like yet, but we've got some likely idea. What would be the best thing for somebody to do? Because you're going to have employers that have quite light touch sort of contracts that they've had for years and years, and that's what they use, and that's kind of the limit of their sort of employment paperwork, I guess. And then you're going to have bigger businesses as well that have a lot more, but they're still going to have extra to do. What would be those first steps or key takeaways?
Yeah, I think that's right. I mean, I think a lot of people think this doesn't happen for us. Certainly what the change of emphasis of the law seeks to do is get employers to think ahead and plan and say, if there's now a proactive duty, you have to take more responsibility for it. And that means probably three core areas. One is going to be assessing the risk to your employees. So understanding what in your workplace presents a risk, and that's very different for different sectors, for different um, businesses, even for different personnel within businesses, so different levels of seniority. Um, so you might have a business where you have lone working, perhaps care industry, for
Yeah.
example. What are the risks to those individuals traveling to and from work, working on their own? There'll be risks involved with people who work with alcohol, for example, that will be different to those that don't. Um, there'll be office environments where they have to have their own assessment. So the first thing is trying to understand where those risks sit
Hmm.
within your business. Um, the second is absolutely the point you made about having the right contracts and policies in place. So you've got that tangible evidence to say this is what we say we're going to do. And that means policies around discrimination, harassment, victimization, etc., equality, essentially, to use one word. Um, Policies around grievances, how people can report, raise concerns about these issues. That probably needs a lot more clarity. Um, and I think in uh, some of your discrimination and harassment policies, spelling out how people can raise the concerns and what's going to happen is pretty fundamental. So how people can raise concerns, how they will be handled, so people can have transparency around that. Partly because you have a lot of um, people who don't raise concerns
Okay.
because of fear of reprisals, the
Yeah.
fear of retaliation, even subtle retaliation, or just that those complaints won't be taken seriously. And then um, training is absolutely one part of it. We've spent lots of time this year, as I said, with our commercial clients, delivering that, supporting them to deliver that, working out the best way for them. It's probably fundamental, and it's fundamental to be doing it regularly,
Hmm.
and assessing risk as that evolves for the business. So a business of 50 employees will be very different to a business of remote workers with 150. Um, so all of that's particularly relevant. And having that in place, and then just culturally, so there's no point having policies written down if actually they aren't sort of lived and breathed. So
Yeah.
having a culture where people feel able to speak up, know that they're going to be treated sensitively, know that their complaints going to be taken seriously, know that if they're alleged to have done something, that there's going to be a fair due process.
Yeah.
um and yeah, just I guess uh walk the walk, really. So know that your policy might say one thing, but if it's always ignored, or people don't get sanctioned for repeatedly doing the same sorts of
Yeah.
things when your policy says they should, um, that's not going to sort of develop trust for people. So the culture piece is really important.
And there's two sides, I think, to all of the points you raise. And as you were talking, I'm sort of thinking about that and going back to the example you gave around a hotel, for example. So you've got the people that work in that hotel that have got third party guests coming in, but let's say delivery driver dropping off something, then he's that, but then he's also an employee. And so then the people in the hotel that he might speak to, so he speaks to someone else, and the two guys are talking. They're both employees, but they're both also third parties with responsibilities. So all of a sudden, this situation, I guess, expands, and that's going to be quite difficult, isn't it, to measure or manage, or when you look at actually the grand scale of how wide that net could go within your own organization.
Yeah, absolutely. I mean, there's often, I think, particularly when you think about regulated environments, you've got lots of other considerations beyond just the person who's making the allegation, the
Yeah.
complaint, the person who's alleged to have done something wrong. Yes, you might have considerations about disclosures to their employer, to other parties, possibly
Yeah.
um, regulators. In lots of the cases we do, there's often a criminal element to it too. So you then have to think about your obligations to report, potentially to the police, or at least be involved in that investigation potentially. So and then it's also about supporting your employees as well. You've got a duty of care to them. So,
Yeah.
and in the context probably of data protection legislation. So, uh, it's complicated.
Yeah.
It's only going to get slightly more complicated, I think, with the third party
Yeah.
involvement. You've previously had perhaps an um, undesirable position where your employee has been harassed by a third party, and they can't do anything about it legally. So they can't sue you, they can't sue the third party because there isn't that direct um, relationship. So um, that does close the loop a bit for them,
Hmm.
but it obviously makes things more challenging for employers.
Yeah. And it's a challenging time, I think, for employers, uh, not from just the legal perspective, but from a financial, tax, general sort of business environment. So I know that some of our clients feel this is another kind of thing that's landing at their feet. And what we've spoken about so far does indicate there's a lot for employers to take on board. But it's not worst case scenario all the time. There's definitely some positives that come out of this in terms of your employees feeling safe within their own workplace and when they're maybe out and about now or engaging with other people, as well as setting great examples and best practice examples for others. But for a tangible, Megan had written down on the questions here around examples, and I know that's quite difficult to give. But are there any sort of really easy examples for employers that could say, okay, this is the types of situations on the very lowest scale that you might find, and these are how we would address them, just to give business owners, I guess, something tangible to be able to go, okay, yeah, I can resonate with that, and now I know what the next steps are that I need to take.
Yeah, do you mean examples of what they can do?
Yeah, just examples you've maybe seen of things that are going to fall under this that you might not expect to be um, fall under harassment or sexual harassment, and actually, then what if something was in place, it would have stopped that, or it would have helped mitigate that situation getting as far as you being involved, I
Yeah,
guess.
sure. Um, I guess that's quite difficult because like I said, every workplace is different, and actually, um, the context of what we're talking about is all underpinned with reasonableness, subjectivity often. So it will be different, and something that might be acceptable in one workplace and lawful, and interactions with particular people in one workplace might be different somewhere else. So you have different cultures, and
Yeah.
and the law does take that into consideration. So um, it is reasonableness. It is about wanted or unwanted conduct, etc. I think certainly an employer that takes the responsibility seriously from the outset. We've got a case we're acting for an individual, um, and we're representing her in a claim for sexual harassment. The new duty that came in October, um, came in on the 26th of October, and what that meant was overnight the law had changed,
Hmm.
and in the part of the defence to the claim, that employer is saying, well, when we learned about her complaint, we then provided training to all of our staff, on sexual harassment. The difficulty they will have with that argument is that it's too late because, um, the event complained about took place after that date, and so immediately they haven't. They're almost saying we haven't complied with the proactive duty. We've tried to do it retrospectively. So the implications of that are significant. We're talking about a 25% uplift on total compensation, and where that compensation is uncapped, um, could in theory be career loss.
Yeah.
That's hugely significant. So I think getting in place, taking it seriously and getting things in place early, particularly with the third party changes that are likely to come in next year, um, understanding what that means, who comes in and out of your door, who do you, communicate with, what's your procurement process now, um, what are you renewing over the next couple of years, and then how do you make sure that your terms, um, with your suppliers reflect that law change that we're
Hmm.
going to see. So it's trying to be proactive, it's trying to
Yeah.
get ahead. um, it is about fundamentally trying to protect your people and protect your culture, and the consequence of that is often a good news story for you because it's about reputation. It then feeds into retention,
Hmm.
and the ability to recruit, because that's so key. You do a lot of that here, where you talk about your culture, and that's, I think, really fundamental for your recruitment drive. So, um, we and we're the same. Stephens Scown, I think our culture is really important. It's often what attracts people to us as a firm. Um, we undermine all of that if we haven't got in place, the sort of fundamental protections that every employee should expect.
Yeah, it's all good saying it, but if in practice that isn't actually what happens when a situation arises, then as you say, it just completely tears down everything you've
Yeah.
kind of built in terms of reputation. And I just want to ask a question about what you said on the the contracts with suppliers and what you have in place with the people that are potentially coming in and out of your business, is that something then that you would expect to see in sort of service level agreements, something that makes reference to these changes around how the people representing those companies should be acting and engaging with the people in your business? Is that something?
Yeah, so yes, I
Okay.
think in a short, again, the responsibility is that you can demonstrate that you've proactively taken all reasonable steps to prevent.
Hmm.
So that's the context in which you're working. I think even beyond that, even if the law weren't changing, you still want to protect your employees.
Yeah.
And so it's right that you're mindful of who you're doing business with.
Hmm.
Um, and that, you often have zero tolerance approach sort of fairly loosely thrown around. Going back to the hotel industry, you have that we won't tolerate
Yeah.
um, anyone speaking to us in a particular way, which is great. Um, but that only really works if you can sort of back that up. I
Hmm.
think so. It's what you do in practice, and it's what sort of agreements you've got in place. So I think it wouldn't be new to have procurement processes which think about who they're doing business with. There may be policies that employers have where they look for particular types of business with certain values, for example.
Yeah.
All of this is just a bit of an extension to that. So, do you want to? Are you prioritizing B Corp businesses when
Exactly what
you
I was gonna.
when you
Yeah.
think about? And it's that sort of thing, isn't
Yeah.
it? It's just saying, actually, we want to make sure that we're engaging commercially with the right people
Hmm.
with shared values so that firstly because it's what we want to develop in our
Yeah.
communities, and secondly it's because it's the right thing to do for our teams and our people.
Yeah, and that's where those types of accreditations like B Corp, that you've gone through a process that really proves that you do want to look after your people, your customers, the supply chain, the environment, everything, all parts of it, that you've considered the engagements that then make it easier to say, well, through this accreditation, I've clearly thought about everybody. So that's where this movement, this kind of be better movement comes into its own, because it will start to help give that context that you need to provide evidence that you've done what you need to do. So actually not just from a it's good to do legally, it's going to be able to help you as well moving forward.
Oh, for sure. I mean, I think, and it's not groundbreaking as a concept. Which employer doesn't want their employees treated with dignity and respect? I mean, I
Yeah.
think that should be pretty fundamental. We're talking about, for sexual harassment, we're mostly talking about women who are the complainants of sexual harassment, overwhelmingly so. And you've got statistics from the Fawcett Society, which is a charity campaigning for women's rights. I think it's published in 2021 that um, that said that around 40% of women have been sexually harassed in the workplace. That goes up to 62% for those aged 25 to 34, and something like two-thirds have been sexually harassed three times or more. But also that's around 70% didn't report it to their employer either,
Hmm.
for the reasons we talked about earlier. So um, you've got a huge percentage of your workforce, particularly female workforce, who continue to be treated in a way which makes them feel like they perhaps don't want to be at work. I mean, in lots of cases, it's really a life changing experience for
Yeah.
them. Even some one-off examples of treatment. So and it can be very difficult to recover that trust. So it's you're doing it for all sorts of reasons, but if nothing else, commercially, it makes sense for you to keep your good people, to be able to attract the right people, and to help them feel safe and secure at work.
Yeah, absolutely. And, as you say, when people feel safe, they feel secure, then they're doing their best work and they're bringing their best selves. And then as a business owner, you're going to reap the rewards of that. So I think it's business owners understanding the whole picture rather than it seeing like a legislative burden of, oh, something's changed now, I've got to go and spend this money and change it. It's like, well, actually, why has it changed? There's clearly something's not right and not working how it is, and we need to look at that and create a bit more accountability across the board. So it's, I think, having that understanding of everybody's role that they play. And
Yeah, yeah, and it's difficult, isn't it? Because these law changes mean increased cost, and likely to mean increased risk. Um, that's difficult
yeah,
in these economic times of uncertainty. Um, and employers will feel that it's just another way of hitting their bottom line potentially. I think you like I said, you balance that against everything I said um, about in the context of retention, recruitment, people being productive, people feeling safe and secure, people wanting to be there, um, and maybe you offset that, and maybe you actually you reverse it and create a much better productive workforce.
yeah, absolutely. And I think that's the sort of key message here, is that doing this right will actually have more benefit for you. It's trying to not do it or retrospectively do it that's going to end up costing you,
Well, and
and dearly.
just to add to that, I mean, I think the consequences we see of disputes um, that get to our team, or we're representing them in the tribunal, um, it isn't an exaggeration to say they're life changing. I think you think about a complainant who's um, been subjected to harassment. They've then perhaps not been. They've complained about it. They've perhaps not had that handled very well. Um, the impact on them personally is hugely significant. Often, the impact on the person they complain about is too.
Mhm.
I mean, these are individuals who can be named in legal action, so
Okay.
claims can not just be brought against the employer, but they can and often are brought against the perpetrators or the alleged perpetrators as well. Um, and the consequences for all of the rest of the team left behind, potentially, there might be both people might have left employment for potentially different reasons. Um, the impact on the culture, I mean, particularly if you think about this involving senior people,
Yeah.
the knock-on effect is huge. So it's yeah, absolutely right that there's context and balance to think about.
Yeah. A lot to think about, I think. And that feels like a good place to leave it. And I guess for anyone listening who's an employer, the first step is just to speak with an expert who can just let you know where your risks are, sort of how you can better ensure that your team are safe and that you are safe as an employer. So it's probably step one, I guess, for anyone.
Yeah, understanding risk, understanding what you need to change, getting the
Yeah.
right advice and support with that, absolutely key.
Perfect. Well, thank you so much for coming on and explaining what feels like legal minefield at times, and putting it into sort of more easy to understand terms for me, anyway, and hopefully anyone else listening. But thank you, Joe, for coming on today.
Pleasure. Thanks for having me.